So, good morning, one and all, and welcome back to the Rhine Report. First, before anything else, my humble thanks to all of you who have responded to my previous posts and to those who commented on it and subscribed. It cheered me up no end. It cheered me up a bit in the face of the disaster we are now living through. But I didn't get much sleep last night because a rogue or a very stupid judge in Chicago ruled against the city's complaint requesting interim relief in the form of an immediate TRO to prevent Trump's army of Texas National Guard minions from invading the sovereign territory of the state of Illinois and the city of Chicago before incredible damage to its citizens was carried out. She, and I think her name is Judge Perry, unlike the Oregon federal judge, Judge Imminent, who has issued not one but two orders blocking the government from implementing its plan to occupy Portland, and Judge Breyer in California, she has allowed the fox into the henhouse from which it will be ages, given the multitude of legal conventions and options available to Trump and his evil regime, if ever, before justice might be seen to be done and this monstrous army of morons are expelled in a judicial order and sent packing to their lairs in Texas. The best example of this being that Judge Breyer was overturned in the Ninth Circuit Court of Appeals, staying his original injunction pending a determination of the case, and the military remain in place while this is being heard by the Court of Appeals, and this is going on for now months. While remembering also that our fascist majority Supreme Court has repeatedly stayed injunctions and TROs on emergency applications by the Trump regime, which is yet another disturbing problem. So, Judge Perry has either misunderstood or deliberately ignored the very meaning and purpose of a TRO, and I am simply flabbergasted by her decision, which not merely makes no bloody sense, but it flies in the face of the facts and judicial balancing act of the evidence and the relative positions of the parties, as well as a presumption based on historical congressional legislation, legal precedent, and foundational principles that point toward the lack of a government case to make or carve out an exception to the Posse Comitatus Act of 1878, prohibiting the occupation of civilian streets by the military carrying out law enforcement. Judge Perry reasons for declination to issue a temporary restraining order, noting she didn't have time to go through hundreds of pages of legal filings, is a shallow and complete nonsense. TROs often come before the court ex parte. That is, it's between the court and one party. The other party does not appear, and they are granted as a precaution against harm or damage to the requesting party, and I have had first-hand knowledge of this in my past experience as an advocate in family law custody cases. So in other words, TROs come first and the full papers come second. In declining to immediately block the Trump administration from sending National Guard troops to Chicago from Texas, Judge Perry strongly urged federal officials to hold off deploying guardsmen until Thursday, when she will hear arguments in the case. Is she incompetent or what? Strongly urged? She should have made an order, period. A government lawyer told her that the troops were already on the way to Chicago. In a very brief hearing on Monday afternoon, Perry said she was, quote-unquote, very troubled, oh dear, by the Justice Department's attorney's inability to answer her questions about where the guardsmen would be deployed and what exactly they'd be doing. This all sounds very familiar to me. And I'll quote from her again. If I were the federal government, she said, I'd strongly urge holding off until Thursday. But she added, it's up to them. She is either one hell of a fool or a miscreant judge bending over backwards to accommodate the Nazi executive and Nazi DOJ. Okay, so in keeping with my posting practice, let's look at the four-factor legal test that applies here and should be immediately argued. I'll read from it. Make things simpler. The TRO standard refers to the four-factor test courts use to determine if a temporary restraining order, TRO, should be issued, requiring the party seeking the TRO to show 1. A likelihood of success on the merits. 2. A likelihood of irreparable harm without the order. 3. That the balance of hardships favors them. And 4. That the injunction serves the public interest. Now, this standard was set by the United States Supreme Court in Winter versus National Resources Defense Council, Inc. Lastly, I can go through the four elements, but it seems clear to me that Chicago will or should win on the merits, especially if the legal pretext for the military invasion is under the same 10 U.S.C. 12406, and we can rely on the order and formidable opinion of Judge Breyer in the California Federal Trial Court. The irreparable harm completely favors the complainants, whose citizens will bear the brunt and fear of having military in their streets, including possible protests and bad actor actions by the untrained troops. The government bears exactly no hardships, while the burdens fall upon the shoulders of the citizens, and the public interest absolutely demands the granting of a TRO injunction. So all of this is a blow to the defenses that we have tried to put up, we as concerned citizens, as I've outlined in yesterday's podcast, and it flies in the face of the vast majority of federal trial courts in America doing the right thing, as evidenced by Judge Breyer, Judge Imminent, Judge Boasberg, Judge Young, Judge Zinnis, and others. So there we have it. That's it for today. What can I tell you? Thanks again for all the comments, the subscriptions, the likes, and the interest. It is really appreciated. God bless.